Number 152, matter of Cortorreal versus Annucci.
Good afternoon. May it please the Court, I'm Matthew McGowan of Prisoners Legal Services of New York for Appellant Rafael Cortorreal. Could I request 3 minutes, please, for rebuttal, Your Honor?
Yes, sir.
This case raises two questions concerning the due process safeguards needed where a requested inmate witness refuses to testify in a prison disciplinary hearing. The Appellate Division has read this
What
court...
exactly should the hearing officer have done that was not done here?
In this case, as to the initial three witnesses, Mr. Harris, Vargas, and
Blackman.
as to those three witnesses who responded merely that they wouldn't testify because they didn't wish to, we think that there should have been a further investigation, whether delegated to a corrections officer or directly by the hearing officer himself.
Yeah, but let's say we don't agree with you about that, and we focus in on just the witness who put in the affidavit, Blackman, I think his name was. In his testimony. Yeah.
As to Mr. Blackman, we think that the only sufficient safeguard would have been a personal inquiry by the hearing officer, and that's because of the sensitive nature of the threat to an uncoerced
Was the officer, or was the sergeant, or whoever the correction officer was that the hearing officer asked to inquire of that witness, was he the person who made the threat or allegedly made the threat to the inmate not to testify?
He was not, Your Honor. Mr. Blackman
He was
alleged...
totally divorced from this proceeding, other than being requested by the hearing officer to make the inquiry.
That's accurate. And the record also shows us that that sergeant, in fact, didn't inquire about any ongoing effect of the coercion. He testified only that he had not personally threatened Mr. Blackman, observed others do so, and that Mr. Blackman hadn't just volunteered any information about ongoing effect of the coercion.
And he asked him if he wanted to testify, right?
Yes.
He asked him again. But your position would be that we make a rule that says the hearing officer has to personally follow up.
Yes.
And wouldn't a different way to look at this be, it depends on the facts and circumstances of the case. So in this case, it's not the officer who allegedly threatened a person. This prisoner is in a different facility, as I understand it, from the facility he was in when this threat allegedly occurred, and he does it through this officer here. Why would we want to make a rule one size fits all on what follow-up a hearing officer would have to take in every case?
That's because any express allegation of coercion by a uniformed security staff member is a really dire threat to the due process right here, in that sending another uniformed staff member, it's still an agent of the state, a member of the same agency, the same security staff, the same union who levied the initial threat against this individual. There's every reason to believe that he wouldn't be at ease discussing a threat that a correction officer had made against him in that.
Counsel, can you tell me what status the hearing officer is in? Do they bring in someone from outside of the prison who is not a correction officer to conduct these hearings?
So the hearing officer at times is an agency employee directly. It might be a high-ranking security staff member. There are also commissioners' hearings officers who are employed by the agency, but generally are attorneys. But the hearing officer is the finder of fact in this proceeding, who is ultimately an employee of the Department of Correction and on community supervision.
One of the things I noticed is that neither party briefed the remedy issues. Do the parties, I know you're only speaking for yourself, but what's your understanding of it? Do the parties concede that remittal isn't a remedy? If the court ruled in your favor that expungement would be required?
Your Honor, we think expungement would be necessary here, both due to the gravity of the offense and on a balancing of the
Well, you
equities.
recognize that neither of you briefed the remedy issue at all.
Your Honor, it was briefed before the Third Department, but I recognize it would have been prudent to brief it to this court as well. We do think that expungement...
You got to take a shot. If you're going to try and win, you might as well try and win, right?
That's right, absolutely.
So what the heck?
And in this case, a balancing the equities certainly weighs in favor of expungement. More than 4 years have passed since the incident. Appellant finished his solitary confinement sentence more than 3 years ago. There was no loss of good time imposed. All of those factors under the balancing of equities test used by the appellant division weigh in favor of expungement.
Getting back to the actual duty of the hearing officer, counsel, in Barnes, didn't we give 3 alternative ways to handle witnesses and when they decide not to testify? And weren't those all in the conjunctive? You either do one thing or another thing or the third thing, and the third thing being that the hearing officer personally inquires of the witness whether that witness wants to testify.
Yes, Barnes found that where 3 alternative conditions weren't met, there was a violation of the right to call witnesses. The third being that the hearing officer communicated with the witness to verify. And that is one of the touchstones of the witness refusal jurisprudence, which is that the authenticity and voluntariness of the refusal is a critical component that the hearing officer must be concerned with. And in the instance of a vague or non-responsive statement, like those given by the initial 3 witnesses, that's an inherently suspect scenario.
So you're suggesting that we extend Barnes, or we change the rule that we've already decided, and to add a 4th category? I'm not sure what you're asking us to do.
The rule of law that we would propose is that in any circumstance where there's an express allegation of coercion, there always be a requirement for personal inquiry just due to the highly sensitive nature of the due process threat presented. In any circumstance where a witness states merely that they don't want to be involved or don't wish to testify, there always needs to be some further inquiry, whether delegated.
How deep should the inquiry be in terms of a coercion allegation?
I'm sorry, Your Honor?
I'm wondering whether or not you're suggesting that the hearing officer inquire as to the witness or as to the alleged coercer, or whom?
The ideal inquiry in this case would be with the witness himself or herself, and it would involve questions concerning whether the threat was in fact made, any ongoing effect that that threat or coercion has on their willingness to testify, whether there might be easily implemented accommodations or remedies that might put them at ease and allow their testimony.
It seems to be a really impractical rule. It wouldn't be meaningful inquiry in some form in line with Barnes without requiring that specific hearing officer had to make that specific inquiry.
Respectfully, Your Honor, we don't believe it would be a major burden in that it's routine when witnesses are transferred to other facilities. They can be contacted by telephone. Their testimony can be obtained in any number of ways, which wouldn't be a major onus on respondent or the agency.
You're not saying it has to be an in-person interview. You're saying it could be by phone.
Correct. In this
It's just
case,
that the hearing officer, he or she must actually engage with the inmate who claims that there's been some coercion.
that's right. In that forum and that interaction will allow the most meaningful exchange. There can be an analysis.
And if
of-
the requested witness ends the inquiry by saying, I don't want to talk to you, does the hearing officer have to go further?
As long as there has been that meaningful and personal engagement with the witness, then that would be sufficient.
So he doesn't have to get to resolve the underlying whether there was or wasn't?
Well, since the witness can't be compelled to testify, what we're looking for is not
Compelling
alone.
him to testify, trying to vet whether or not he was coerced.
That's right. In that, as long as the hearing officer is taking substantial and meaningful efforts to interact personally and to try to bring to light any possible coercion and to present possible accommodations that might allow the testimony, that would be sufficient.
Can I ask, does the hearing officer need to simply consider or engage in this conversation to determine whether or not that inmate feels currently coerced? That maybe there was coercion in the past, but what's relevant is whether or not there's coercion now with respect to appearing now. Is that what the focus of that conversation should be?
The focus should be the ongoing effect of the coercion, with the caveat that the rehearing has occurred. I mean, in this case, there was an initial hearing reversed on other grounds, a rehearing now at issue, with the caveat that there hasn't been a sufficient separation in time that it would be wildly implausible that it might have some effect.
Thank you, sir.
Thank you.
Counsel?
Good afternoon, Your Honor, Andrea Oster. I think there's a lot that the parties agree about here. So we agree that where there are witness refusal forms that appear suspicious, a further
Why
inquiry...
not when there is an inmate who says, I was coerced and that's why I was
And there's
I
no-
refused. Why not just have the hearing officer either do it in person, that's what the hearing officer thinks appropriate or easily available, or just get on the phone? Say, do you currently feel coerced? Is that why you won't
Not always
testify
feasible.
now?
It's not always feasible, and we're worried about
Why
the
is it
safety
not
of the inmate.
feasible?
Because the hearing officer and the refusing witness, as here, were not at the same facility. That means organizing that telephone interview means the inmate has to be escorted from his cell to a private room for a telephone call. And even if all he says is, "I refuse to testify," if that inmate is found guilty, as he was here, on the basis of confidential information, it's going to look like he was a snitch. And so, if you look at it from the witness's perspective, he doesn't want that escort. And in fact, docs did an experiment for a while, because the hearing officers, even when they were at the same facility, were uncomfortable going down the block to interview people personally. They were
Here
being-
it's a little odd, though, because here he signed an affidavit.
Yes,
So
yes.
I don't think he's worried about being a
And that's quite
snitch, though.
extraordinary. No question, that is quite extraordinary. And the
And
reason...
isn't that then, doesn't that make this a different case from the run-of-the-mill case where an inmate
It
might
does.
say, you know, I don't want to testify, I don't want to have anything to do with this, I don't want to talk to you anymore, I have nothing to say to you?
It does. But as Your Honor has pointed out, these cases are so fact-specific. And on the facts of this case, this hearing officer's additional inquiry, which he did do, was sufficient. Why?
Well, it's not his inquiry, right?
Well, this hearing
He has
officer,
someone else go ask.
he did a further inquiry. I didn't say he did a personal interview. He did something further, right? He got the testimony of the CO who tried
But
to...
isn't that the point? If the coercion comes from the staff, why is the hearing officer asking another category of staff to go ask that question?
I would ask Your Honor to just consider the particular facts here, which are these. This sergeant at the second facility, the inmate is now in upstate New York, goes to ask if he will testify. And even though just 4 months earlier, he was willing to take the extraordinary step of putting in an affidavit saying, "I was coerced," and naming his alleged coercer, he says nothing about any continuing coercion. Doesn't his silence
Maybe
give
he's
rise
not
to an
saying
inference
to
that he
the-
doesn't
Maybe he's
feel...
not saying that to the officers, right?
Well, doesn't his silence give rise to an inference that he doesn't feel any
Isn't that what the
continuing
hearing
effects?
officer should inquire? I mean,
Would
their
it have
point
been-
is, isn't that for the hearing officer to at least engage with that inmate to make that determination, as
Well, you're saying-
opposed to when you have, as you say, extraordinary situation.
Yes.
Where the inmate signs an affidavit saying, yes, I was coerced, admits that publicly in this way, or at least in this particular
Yes,
situation.
he admits it publicly.
Completely unusual that the hearing officer would then send potentially a person sort of standing in the same posture as I know it's not the same individual, but in that same relationship to an inmate to ask the question?
I would say this, Your Honor. Given the facts of this case, he is sending his delegate, who's now 300 miles away from the alleged coercer, and we checked, that CO is still at Sing Sing to this day. So he's asking someone 300 miles away to go ask for this. Would it have been better if the hearing officer had advised that CO in advance about this allegation? Certainly. We think the hearing officer's additional inquiry was still
Would it not be better if the
good
hearing
enough?
officer perhaps put on the record why the hearing officer, in this case he himself, was not going to contact that inmate and thought that this was appropriate, notwithstanding the claim of coercion, thinking this, under all these facts and under these circumstances, I think this is appropriate?
I would ask Your Honor to to consider this court's decision in Abdur Rahim, where the court rejected a rigid rule that would require hearing officers to personally interview confidential informants every time.
Counsel, separate issue.
Yes.
Is this issue specifically preserved below,
Which issue?
the issue on Blackman and whether it should have been a personal follow-up call?
The parties certainly briefed, and yes, I mean, the inmate objected at the hearing.
But in the petition before the Supreme Court?
In the petition, I would say it's, the focus of the petition was the not getting the unredacted refusal forms, but we certainly never raised a failure to objection. So we are treating it as properly before the court. And I also want to be sure to, Your Honor mentioned why the parties hadn't
Yeah, the
briefed
remedy issue. I just didn't, I wanted to hear what you had to say, too.
Well, in this case, the agency has already decided that a fair rehearing can't be had. This incident happened 4 years ago, so they're
So you
not
concede
interested.
in this instance
So
expungement.
we're not asking for remittal. The agency's position in general, as we have briefed in other cases before this court, but the court didn't reach, is that a procedural issue, the default rule should be remittal. It's just Docs isn't interested in pursuing a remittal here, so we have agreed to the expungement. And then I would just say, as to the other...
I'm sorry, did you say you've agreed to the?
We would agree to that
Oh, you would
remedy if the
agree.
court finds error. Yes, thank you, Your Honor. As to the other written refusal forms, the ones from the other 3 inmates who didn't suggest any coercion, I would just say that absent additional suspicious circumstances, it is reasonable for a hearing officer to accept the voluntariness and authenticity of those forms. There were no additional suspicious circumstances as to those forms, and that's why it was reasonable for the hearing officer to accept them. An additional inquiry in all of those cases, even through a hearing officer, may seem small, but in fact, it's enormously burdensome, and therefore, we'd ask the court not to impose that rule unless it finds it's necessary. And just to give the court some context, in 2015 alone, Docs completed 65,000 disciplinary hearings. That's an average of something like 5 new hearings at every workday, at every facility throughout the state. And as you know, even from this case, these hearings go over multiple days. Inmates ask for multiple witnesses. Unlike in other states, which restrict the number of witnesses that an inmate can request, Docs doesn't impose that restriction. We have multiple inmate refusals. I don't have statistics for you on how often inmates refuse, but I'm advised, and I know from our own litigation experience, it's common. And the single most common reason that inmates give is that they don't want to be involved. And that's not inherently suspicious. Inmates are understandably afraid of retribution and retaliation, and unfortunately, not wanting to be involved is consistent with human nature. So absent an additional suspicious circumstance, we would say that it's fine to accept that written form.
Thank you, counsel.
Thank you.
Counsel?
So, counsel, if the hearing officer had actually put on the record why he chose to pursue this question about Blackman's coercion in the manner that he did, would there be any basis to disturb that decision?
I'm sorry, had he put on the record?
Let's say decide what I had asked counsel. He said, I've considered whether or not I myself
Yes.
should do a personal interview, and I deem that unnecessary under these circumstances, and gives a reason. Is there any reason to upset that? How would we review that?
There's 2 reasons to upset that. First and foremost is that because of the particularly sensitive nature of the scenario, sending a hearing officer or a hearing officer communicating by telephone, as the case may require, is the only way to truly root out any ongoing effective coercion, in that sending someone in functionally the same position as the person who levied the threat is so unlikely to render a truthful response that that's not
So
sufficient.
you're
to
saying that
protect.
as a matter of law, a hearing officer under these circumstances could never send
As a matter of law,
a
where
corrections officer to ask this question?
where there has been an express allegation of staff coercion that strikes so closely at the heart of due process that there always would need to be some meaningful and direct communication between the hearing officer and the requested witness. But beyond that, on the specific facts here, the hearing officer sent a sergeant who didn't inquire about ongoing effect of the coercion at all. It's clear from the record that Sergeant Maddox, when he spoke with Mr. Blackman, asked only if he was willing to testify. He didn't
You missed the point.
Yes, absolutely. And I would urge Your Honors to bear in mind that the due process rights of prisoners in these administrative hearings are distinctly limited, and the stakes can be incredibly high. In this case, it was a year of solitary confinement. In some cases, it's months or years of lost good time that can extend incarceration. And therefore, the added burden of simply having the correction officer who interviews a witness ask a single follow-up question, noting that the response they gave was evasive or non-responsive, and then confirming that they in fact are refusing to testify, wouldn't be a radical change in the current jurisprudence or in the current procedure.
But it is to the extent that you say only the hearing officer can ask that.
That's-
You're not agreeing that if the sergeant had actually asked that, or asked about that, and had gotten a response, that that would be good enough?
To clarify, that would be as it relates to Mr. Blackman in the instance of express allegations of staff coercion. As to the other 3 witnesses who gave vague and evasive statements, that might be delegated, and it could be done without some particularly serious burden.
Thank you.